Hi there, I'm Cassandra Van with the Home Advisors team here at Keller Williams Realty. Today we're going to be talking about divorces and real estate. I'm here with?
Art Fulmer, and I own Fulmer Law PA.
Awesome. How did you get started and what kind of law do you practice?
I practice primarily marital and family law as well as criminal defense. I initially started as a public defender and joined my father's law firm, and we were partners until he retired.
Great. So how often do you see real estate becoming an issue with divorce cases?
Real estate is an issue in just about every divorce case. Certainly if they own any real estate, it becomes kind of one of the bigger focuses.
What do you think is a general thing that divorcing couples need to know about property division?
Well, there's a number of ways to get there, and typically what we like to try and do is come to some sort of agreement where the parties can equitably or equally, in some cases, divide their property. And if that can't happen, then we can bring various issues like that to the court for the judge to address.
Okay. So how's a family home typically handled during a divorce?
Usually one party will either keep the home and refi the mortgage into their name and buy out the other party's interest, or it's sold.
Can the parties legally remain in the home during the proceedings?
Parties can remain in the home, and in some cases they do. However, if there's problems or domestic violence or other kind of serious issues, the judge can order one of the parties to vacate the residence and allow one party to remain there.
So what happens if only one person's name is on the home? Does that mean they own it?
It actually does. It means they own it if they're the only party on their deed. However, if it was bought during the marriage, it generally is considered a marital asset and both parties have equal ownership. However, sometimes you have to track where the monies came from to purchase the house. But generally speaking, if it was bought during the marriage, they each own it.
Regardless of whose name is on it.
Right,
Yeah.
correct.
So how do courts generally decide who gets to keep the house?
Most judges allow the parties in their counsel to figure out who's going to keep the house. And if they can't, the vast majority of the time, if the parties can't agree who's going to keep it, the judge will say, well, then we're going to force the sale. And the judge will enter an order forcing the sale of the home.
Okay. And then neither party gets to keep it.
Then neither party gets to keep it.
What role does home equity play in a divorce? If there's equity in the home, there's a value in the home, how does that come into play?
It's huge. The party that is going to keep the home, for example, is certainly going to owe the other party the equity in the house. However, it can also be negotiated. So if there's another asset that they want to keep, or if there's something over here that they find more desirable, you can negotiate that equity to offset whatever it is that they want to keep.
Okay. And so can you force a spouse to refinance the home after the divorce?
Yes, but you got to be kind of creative there and make sure you have good language in either your agreement or court order to order the party to refinance, and then also have a backup kind of contingency if they're not able to qualify.
So getting the right attorney makes the difference.
It does make the difference because you want to think ahead as to what's going to happen, because the bank is the one that's going to decide ultimately if they're going to allow the refinance. So if the bank denies them, you want that contingency that says, well, here's what's going to happen if that happens.
Does each party need their own attorney throughout the divorce?
Yes, they're absolutely going to need their own lawyer. And it's unethical, actually, for me to advise another party in a case.
What are some options if neither spouse can afford or neither spouse wants to keep the home?
If they can't, which we were running into, sometimes they'll take out a HELOC or they'll just owe too much debt. We will usually come up with some sort of generally there's going to be some equity in the house, but if they can't afford it and or there's no equity in the house, you're going to have to either, again, agree to sell it, or we can actually work with the bank to figure out what's going to happen if there's money actually still owed on the house or owed for something they did to the house. But that's again, just something you have to negotiate.
Okay. So it's all about the negotiation and what's fair and equitable.
Exactly. And getting creative. I mean, you really can these days, and you could, talk to the lender but yeah, at the end of the day, that's what you're trying to accomplish.
Okay. So what legal protections should someone put in place if they're buying a property during a divorce?
If you want to buy a property while the divorce is pending, you really need to negotiate it through the attorneys so that everyone has an understanding that you're buying real estate, that it is to remain non-marital, meaning the party that's buying it is the sole owner. And you need to take the proper steps so that it's not commingled into the divorce itself, which we do. I just did one the other day. It's not uncommon for parties that are going through a lengthy divorce to do that.
Okay. Is there an average timeline for divorce?
It can be anywhere from 6 months to a couple years,
Yeah,
or even longer if it's really messy.
So what is a lis pendens and how does that apply in a divorce?
Lis pendens is basically it clouds the title to the property. If someone has a claim, a mechanic's claim, or even an attorney's fee, charging lien against it, and puts everyone on notice that this is a debt that is going to have to be satisfied when the property sells.
Understood. What should divorcing couples know before listing their house for sale?
Well, they need to know a number of things, but you really want to agree on a realtor, and you want to agree on who's going to stay in the home, who's going to be responsible for preparing it for sale, who's going to listen to the realtor and be available to show it, and who's going to how they're going to handle the maintenance and the fees associated with getting it ready for the market.
How do you recommend handling the proceeds from the marital sale?
Usually what we like to do is agree for one of the lawyers to hold it in their trust account. That way you can either have an agreement after that as to who's going to get paid what amount, or by judicial order, the court can order who's going to get what. But by holding it in trust, you can help resolve all the other financial issues that the divorce entails.
Is it possible or even wise to keep the home post-divorce?
It is in some cases. A lot of people are very attached to their home and their kids, and oftentimes we find ourselves negotiating how one party is going to keep it post-divorce for their children to maintain sense of security and normalcy moving forward.
And I think most of the time we're talking about their actual homestead, their marital home. How do investment properties come into play?
Very similar to the marital home. You're going to look at what the equity is. You're going to look at if it's going to be sold or if one party is going to be awarded that. And again, that's a situation where once you determine how much the equity is, if a party desires to keep that property, they can maybe forego some other asset.
So what's the biggest mistake you see people who are going through divorce make with their real estate?
Probably not having the correct language in the order or the judgment as to what is going to happen if the person cannot qualify to refinance the house.
No contingency plan.
No contingency plan in place, and it leaves the court with very little authority or jurisdiction to enforce something.
So what's the risk of having a verbal agreement with no legal documents?
Every risk you can think of. So there's no way to document it. There's no way to go back and, ensure as to, how the transaction occurred. And more importantly, there's no teeth, right? You have to have it in an order with language as to how it can be enforced.
No way to enforce it.
No way to enforce it.
He said, she said.
Right.
Okay. What's the first real estate related step someone should take if they're considering divorce?
I would say to agree on a realtor, because if they don't, I've had cases where they will go back and forth and argue about who they're going to hire. This has gone on for months and months, and sometimes you have to get the judge involved and have the judge pick the realtor. All the while, the house could fall into disrepair or the market could go down. So agree on a realtor.
It's good advice. What's the number one piece of advice you would give someone who's trying to protect their home through a divorce?
I would say to get pre-qualified by the lender, have it in writing. The last thing you want to happen is to get to a final trial before the judge and say, well, I want to keep the home. And then the other party's concerned that they're not going to be able to qualify to refinance. And if that's a concern and the court finds it, as such, then they're going to oftentimes order the sale of the house. So get yourself pre-qualified, get the letter, and be able to present that to the court.
So that way you're not all the way through the end finding out that you've been awarded the house, but ultimately you can't even finance it.
Exactly.
If you're considering divorce or facing divorce and you need an impartial realtor, feel free to give me a call, Casandra Van, 863-221-4982.
And if you're looking to hire an attorney to represent you in your divorce, feel free to give me a call at 863 688-2220, or you can visit my website at fulmerlawpa.com.